In this presentation, we will study the United Kingdom new regulation called the Bribery Act. The Bribery Act was adopted by the UK Parliament on the 8th of April 2010. The law was quickly completed by governmental guidance issued by the Ministry of Justice. The Bribery Act came to force on the 1st of July 2011. We will briefly review what is really new in this UK regulation in comparison with the existing international treaties and other regulations against corruption. The UK Bribery Act contains in its Section 7 a new corporate offence, introducing criminal liability on corporate bodies that fail to prevent bribery. Consequently, companies have major incentives to put in place adequate procedures. What kind of procedures shall companies put in place? First of all, the procedures must be adequate. That is to say, proportionate to the level of risk. It is not a matter of the company size. It mainly concerns the countries where the company operates and the person with whom the company deals. Bribery may be direct or indirect. That is to say, directly between the company and the official, or indirectly through a third-party agent. Companies are expected by the Bribery Act and guidance to audit their business. They should, therefore, ask themselves the following types of questions. Does the company deal with local public officials or foreign public officials? Does the company use third-party agents to obtain new contracts? Is due diligence in use inside the company before establishing a partnership? Then, thanks to these self-assessments, the companies will draft a risk assessment in order to estimate potential internal and external risk of bribery. Efficient procedures and clear assessments are requested by the law. Top-level commitment. The top-level management must foster a culture within the organization in which bribery is never acceptable. Tolerance zero. A correlation between bribery and getting fired should be made by the companies. Code of Business Conduct Handbook, Gift and Hospitality Policy, Ethics Policy, Procurement Policy, Data Privacy Policy, IT Policy, Group Approval Process, Disciplinary Procedures, Fraud Policy, and so on. But the anti-bribery program must also be efficient. Not only assessments, but tools and procedures. The company must implement trainings in seminar or classroom format dedicated to employees and associated persons, e-learning session, regular information, regular monitoring of the procedures included in the various handbooks, escalation procedures, whistleblowing speak-out program, regular monitoring on the activity, compliance officer appointment, and so on. The enforcement of these statements and procedures will be checked and evaluated by the prosecutors. Who is concerned by this new offence? All companies having a demonstrable business presence in the UK. So all companies incorporated or having a partnership formed in the UK are obviously addressed by the law. Are also addressed all companies in the world carry on business or part of business in the UK, irrespective to the place of formation or incorporation. There is no requirement of a close connection with the UK, such as UK nationality, UK residence, or incorporation in the UK. Guidelines affirm that the court will be the final arbiter as to whether an organization carries on business in the UK. Associated person. A commercial organization is liable under Section 7 if a person associated with it bribes another person. The person considered to be associated is someone who performs services for or on behalf of the organization. It could be an individual or a company, irrespective of the place of incorporation. So it could be employees located in a foreign branch. Indeed, employees are always presumed to be performing services for their companies. It can also be agents and subsidiaries. But other situations have to be tackled. Contractors. They may be considered as associated persons when, instead of simply selling goods, they act on behalf of the parent company. Contractors and subcontractors. The guidelines underline the fact that the parent organization is likely to have more influence on its direct contractors than on its subcontractors. But, as the text of Section 7 is quite broad, companies are expected to advise their contractors to put in place anti-bribery procedures. These contractors will then advise their own contractors to do the same in order to provide protection at every possible level against a possible prosecution based on Section 7. Joint venture acting in a separate company. A member of a JV may be liable for failure to prevent bribery if the JV is performing services for that member and gives a bribe with the intention to benefit that member. If the bribe only benefits to the JV, members won't be liable for it. Joint venture conducted in a contractual arrangement. The degree of control that a member has over the arrangement is a relevant information in order to decide if a member has performed a service for the JV or in the name of the JV for its own interests or for the interests of the JV. Today, corruption has reached a high level of complexity, using financial, IT, and intelligence networks to operate. Consequently, the examples we have just studied are far from reality. The number of parties involved in a massive corruption system is often huge, and networks are very difficult to identify, as they are often using tax haven and money laundering. The judge has the full power to grant a non-defined fine. This could lead to very severe sanctions, as the fault for not developing a compliance program may not be the cause of the bribery. The Serious Fraud Office. The main prosecution authority in the UK regarding the crime of bribery is the SFO, Serious Fraud Office, which operates in England, Wales and Northern Ireland. The Serious Fraud Office developed an international intelligence strategy with, most notably, the United States Department of Justice and the Securities and Exchange Commission, but also through international and European networks such as Eurojust, the International Association of Prosecutors, and the World Bank. In practice, prosecutors can refer to the Crime and Courts Act issued in 2013 and analyze if a deferred agreement is possible. A DPA is an agreement reached under judicial supervision between the prosecutors and an organization. It may be appropriate where the public interest is not best served by mounting a prosecution. For example, we can mention cases when corruption is not too expanded, or when the prosecution involves national security, or when the organization fully cooperates with the Serious Fraud Office. The agreement allows the prosecution to be suspended for a defined period, provided the organization meets some specified conditions. Conditions attached to the DPA may include disgorgement of profit, payment of a fine, compensation for the victims, cooperation in any prosecution of individuals, implementation of compliance program with, if necessary, the appointment of a monitor. However, entering into the agreement will be a fully transparent public event. Conclusion. With Section 7 of the Bribery Act, the United Kingdom has developed a clear strategy of self-defense, putting companies all over the world under the constraint to develop a program against corruption. In this way, Section 7 is very similar to an antivirus software. As a conclusion, we can mention around 15 ongoing investigations by the SFO against companies, but no prosecution until now.